Good morning, all of you. Good morning to the online students as well. Yes, in the last class, we had completed our discussion on legislature. Yes. Any doubts that you have? Yes. Huh? हाँ. कॉन्स्टिट्यूशनल अमेंडमेंट बिल में नहीं किया होगा. पोस्ट ऑफिस बिल कुछ था वो शायद, है ना. वो कॉन्स्टिट्यूशनल अमेंडमेंट बिल, और कॉन्स्टिट्यूशनल अमेंडमेंट बिल में ये इनिशियली दिस वाज नॉट द रिक्वायरमेंट. ठीक है. It is through a constitutional amendment that they have made compulsory for the president to give assent. ठीक है. पहले ऐसा नहीं था. ठीक है. With respect to the constitutional amendment bill also, the constitution initially did not say that the president has no other option but to give assent. This provision was introduced into the constitution through a constitutional amendment. Yes. Fine, I forget which constitutional amendment exactly, but it was introduced through a constitutional amendment, and that is how है ना, it came into being. तो एक बार dates verify करके we can look into it. Fine. So today we are starting with the topic of judiciary. Yes. So the first idea that we need to discuss, that in case of, there are three organs of the government: executive, legislature and judiciary. We have completed our discussion on executive, now also on legislature. The last organ of the government that we need to discuss, organ of the government that we need to discuss is judiciary. Yes. So when it comes to judiciary in India, judiciary generally is expected to be an independent organ of the government. It is expected to exercise independence. Now, why is it necessary for judiciary to be independent? Yes? Yes. So first let us discuss the meaning of independent judiciary. Meaning of independent judiciary. What do we mean by independence of judiciary? Yes, what do we mean by independence of judiciary? Sorry? इंडिपेंडेंस ऑफ जुडिशरी का मतलब क्या है, ये पूछ रहे हैं कि व्हाट डू वी मीन बाय इंडिपेंडेंस ऑफ जुडिशरी. हाँ, ठीक है. These are ways in which we can ensure independence of judiciary. He is saying that the conduct of the judges cannot be discussed in the parliament or the state legislature, generally speaking. Yes, that is how we ensure independence of judiciary. What is the meaning of independence? Yes. Yes, this is the meaning, as they too correctly said. First, independence of judiciary means ability of judiciary to function without fear or favor. Yes, it is able to act independently. It does not function under fear that what will the executive say, what will the legislature say. Neither does it operate on the basis of any favor. Yes. So basically it is an unbiased way of operation. Yes, an independent way of operation where judiciary exercises autonomy. Yes, judiciary has the autonomy to take its own decision based on a rule of law, based on what the constitution says, what is the normal convention in a country, what is the customary law of that country, whatever it is. So it takes independent decision without influence of any fear or favor. Yes. The other is that there is absence of interference. Absence of interference of the other two branches in the functioning of judiciary. Yes, the other two branches, be it executive or legislature, they should not interfere with the functioning of judiciary. Yes, judiciary should be able to function in an autonomous manner, in an unbiased manner, taking into consideration rule of law, what the judges think is right and wrong, according to the constitution, according to the rule of law, according to the convention. Yes, whatever it is, but there has to be an unbiased operation of the judiciary. Yes, so that is what we mean when we say what do we understand by independence of judiciary. Now, having understood what it means, the question arises, why independence of judiciary is essential? Why should judiciary function in an independent manner? Arbitrariness of the legislature only? हाँ, ठीक है. Yes, to ensure that it is essential that judiciary enjoys independence, because एक तो ये है कि subversion of democracy should not take place. Yes, the executive or the legislature, generally the executive should not start functioning in an arbitrary manner, should not concentrate power in itself. Therefore, judiciary and each organ is expected to exercise checks and balances. Separation of power का concept है, checks and balances, to prevent dictatorship of the other two branches of the government. एक तो ये reason है. उसके अलावा क्या reason है? उसके अलावा ये reason है कि judiciary as such performs very vital functions. ये जो functions perform कर रहा है, they are very very important. Yes, and in such performance of such important functions, it cannot afford interference, it cannot afford biasness. Yes, because that would tantamount to subversion of democracy. Yes, that would tantamount to subversion of democracy. Yes, now we need to list down the vital functions performed by judiciary, but before that, let's just write it down. Write down. Have you given the heading? Why do we need an independent judiciary? And under it, you will have to give the subhead as meaning of independence of judiciary. Yes. Write down. It implies that the judiciary is able to function, without fear or favor. Without fear or favor. Full stop. That is the existence of a fair, impartial, unbiased judiciary. Unbiased judiciary. Yes. Second point लिखो. It means absence of interference. Absence of interference by the two other branches. By the two other branches. Put a hyphen, the executive or the legislature. In the functioning of the judiciary. In the functioning of the judiciary such that it is unable to do justice. To do justice. ठीक है. एक और पॉइंट लिखो. However, independence does not imply. However, independence does not imply arbitrariness. Does not imply arbitrariness or absence of accountability. Yes. So we are giving both the idea, a balanced definition of independence, that it does not imply arbitrariness or absence of accountability. Yes. Judiciary is part of the democratic political structure. It is part of the democratic political structure. And therefore, it is accountable to the Constitution. It is accountable. It is accountable. Accountable to the Constitution. Accountable to the Constitution. Yes. Fine. Next is why independent judiciary is needed. Why independent judiciary is needed. Yes. Why independent judiciary is needed? One, as we discussed, to prevent subversion of democracy. Yes, to ensure that democracy continues to be in operation. Yes, it does not happen that there comes to exist dictatorship of a person or a group. Subversion of democracy नहीं होना चाहिए. Yes. Why else? एक मैंने आपको vital functions बताया, but before we get into vital functions, let us write down one general point, because judiciary is the independent arbitrator, है ना. In case of any dispute, judiciary is supposed to act, है ना. Judiciary is supposed to resolve disputes. Yes, it is the organ which is the arbitrator, which is expected to resolve disputes. Now, if we are going to live in a society, whenever there is group of people, if I exist singly, there is no scope for dispute. But if we exist in a group, in a classroom also there might be dispute. Somebody might want today polity must be taken up, another might be interested in studying geography, and the third person in economics. Yes, so there has to be somebody who is enforcing the rule of law, who is ensuring if and when dispute arises, the dispute can be resolved. So in a society where people exist in groups, disputes are bound to arise. Yes, it can arise between people, between groups of individuals. Yes, so it might so happen that in the class, we are generally in India familiar with Hindi, but there are some people who are from South India might not be very familiar with Hindi. So others might want the class to be taken up in Hindi and English. Others might want, another group might want only pure English Milo class. Yes, so that might happen. So you have disputes are bound to arise between individuals, between groups. And who will resolve? We can also have disputes, for example, between individual or group and state. Yes, so who is going to resolve these disputes? You need an independent, impartial adjudicator. Yes, somebody who can impartially enforce rule of law. Yes, so that is the need, that is the reason why we need independent judiciary to resolve such disputes, because in a society disputes are bound to arise. Apart from it, you find that the Indian Constitution has given Indian judiciary very vital functions that they would be performing. What are the important functions performed by the Supreme Court? We'll just mention the Supreme Court. Yes, first and foremost, it is the guardian or the custodian of the Constitution. इसका मतलब क्या है? Custodian of the Constitution. Yes. बताओ क्या है इसका मतलब? Sorry, any law that goes against the Constitution, how will they act on that? Yes, they will declare such laws as unconstitutional, ultra vires, yes, null and void. So they are custodian. Every law enacted by the legislature, every executive action taken by the executive branch has to be in accordance with the Constitution. Nothing can go against the Constitution or against the fundamental principles of the Constitution. Yes, any such law enacted, any such executive action taken can be declared unconstitutional, है ना, through the option of judicial review. They ensure that they are the custodian of the Constitution. ठीक है, तो एक ये important है. इसी context में इन्होंने है ना basic structure doctrine भी दिया है ना, to safeguard the Constitution. Yes, so India is an example where our Constitution is flexible as well as rigid. We strike that fine balance. What else? Appellate. It is the highest court of appeal. चलो ठीक है, highest court of appeal. और बताओ. Yes, it is to protect fundamental right. Very, very important function performed by the Supreme Court. Yes, under Article 32, you have the right directly to approach the Supreme Court. हमने वहां पे भी पढ़ा था writ jurisdiction. तो वहां पे if the fundamental right of an individual is found to be violated, the Supreme Court is bound to issue a writ. Yes, So you find it is the protector of fundamental rights. Fundamental rights, very important rights for individual to express their fundamental personality. Yes, so without fundamental rights, each of us will lose our uniqueness, will lose our personality. Yes, we cannot develop to our full potential without fundamental rights. And who is protecting those fundamental rights? It is the Supreme Court. What else? ठीक है, कोर्ट ऑफ रिकॉर्ड है. कोर्ट ऑफ रिकॉर्ड मतलब क्या होता है? कोर्ट ऑफ रिकॉर्ड आई एम नॉट गोइंग टू मेंशन हियर, बट यस इट इज अ कोर्ट ऑफ रिकॉर्ड. इसका मतलब ये है कि a judgment given by Supreme Court is recorded, and other subordinate courts can refer to the judgment of the Supreme Court later on to give on similar issues. They can give such judgments. ठीक है, what else? हाँ, लेकिन ये कोलिजियम सिस्टम इज नॉट एक्चुअली मेंशन्ड अंडर द कॉन्स्टिट्यूशन, है ना. ये जुडिशरी का खुद का इनोवेशन है. एंड इन फैक्ट वी क्रिटिसाइज, है ना, देर इज नो 100% सपोर्ट फॉर द कोलिजियम सिस्टम, है ना. अभी फली एस नरीमन पास्ड अवे एंड ही वाज आल्सो अ क्रिटिक ऑफ द कोलिजियम सिस्टम. कोलिजियम सिस्टम के साथ बहुत सारी दिक्कतें हैं. यस, सो व्हाट एल्स? Yes, between center and state to resolve the dispute. So it is the federal court. In fact, it is the sole arbitrator, the only court which can arbitrate over a dispute between center and state or between states. What else? Yes, and Tanushka, and he also is mentioning advisory jurisdiction. Yes, the Supreme Court can also give advice. They can accord legal advice to the president when the president seeks it. Yes, yes, it advises the president on certain matters. Fine. So this is these are some of the vital functions performed by judiciary. Fine. So because it performs such vital function, plus there should not be subversion of democracy, since in a society disputes are bound to arise and there is a need for an independent, impartial arbitrator to such disputes. It is essential that we have an independent judiciary which enforces the rule of law. Fine. So because of all these reasons, we need an independent judiciary. Let's write it down. So you have given the heading why independence of judiciary is needed. Point number 1, write down, in a society disputes are bound to arise between individuals between groups and between individuals or groups and the state. Yes, fine. Full stop, write down, to settle such disputes in an impartial manner according to rule of law. Rule of law, comma, one needs independent judiciary. इसको हम ऐसे भी बोल सकते हैं, है ना, अनबायस्ड मैनर, इम्पार्शियल मैनर, अकॉर्डिंग टू रूल ऑफ लॉ. इसका मतलब क्या है? टू एंश्योर जस्टिस. यस, एंड व्हाई जस्टिस इज एसेंशियल? हाँ, जस्टिस नॉट नेसेसरीली ऑलवेज टू एंश्योर डेमोक्रेसी, डेमोक्रेसी नहीं है, मोनार्की है, डिक्टेटरशिप है, तो भी जस्टिस एसेंशियल है। स्टेबिलिटी के लिए, लेजिटिमेसी ऑफ द अथॉरिटी, है ना, स्टेबिलिटी के लिए एक्चुअली क्या है, लेजिटिमेसी ऑफ द अथॉरिटी होगा तो स्टेबिलिटी होगा बेसिकली, पीपल विल नॉट रिवोल्ट, पीपल विल नॉट गो ऑन टू द स्ट्रीट। इसीलिए कहा जाता है कि जस्टिस शुड नॉट ओनली बी डन, इट शुड बी सीन टू बी डन, ऐसा लगना चाहिए कि जस्टिस हो रहा है, ठीक है, जस्टिस होना सफिशिएंट नहीं है, इट इज नॉट सफिशिएंट that the justice is done, but people should feel yes, we are living in a just society, because that ensures peace and stability. Yes, write down. Next point likho, to ensure justice, to ensure justice and consequent peace and stability, and consequent peace and stability. Yes, fine. Next point, to prevent subversion of democracy, to prevent subversion of democracy. In a democratic society, independent judiciary is essential to prevent subversion of democracy. To prevent, इसी में लिखो, to prevent concentration of power, to prevent concentration of power in any individual or group, in any individual or group. And third point, because Supreme Court performs very vital functions, performs very vital functions. Point number 1, sub point 1, it is the custodian of the constitution, custodian of the constitution. Second point, protector of fundamental rights, protector of fundamental rights, protector of fundamental rights. Third, it is a federal court, it is a federal court, federal court. उसी में लिखो, it is the sole arbitrator, it is the sole arbitrator, sole arbitrator of disputes between center and state, between center and state, or among states, or among states. Fourth point, fourth point लिखो, it is the highest court of appeal, it is the highest court of appeal in the country, highest court of appeal in the country. Yes, and last, it gives advice, legal advice, it gives legal advice to the president when needed, when needed. Yes, when the president refers any issue to the Supreme Court for its advice, it gives such advice. Fine, fine. So this is with respect to the vital functions performed by the Supreme Court. Next, how do we ensure independence of judiciary? How is independence of judiciary ensured? How is independence of judiciary ensured? Yes. So you were telling me a few points earlier. How is independence of judiciary ensured? Security of tenure. Yes. Second, manner of appointment, whereby the judges themselves play the most important role in their own appointment. Yes, what else? Conduct of judges cannot be discussed in the parliament or state legislature unless, yes, unless a motion for their removal is being discussed, is being considered by the legislature. Yes, yes, salaries, allowances, and pensions are charged on consolidated fund of India. Yes, they are charged. What else? Fixed tenure we have written. Security of tenure. Fixed service conditions. Their service conditions cannot be deteriorated to their disadvantage after their appointment. Yes? Yes. Security of tenure में ही आ गया removal वाला ना, कि the removal is not at the whims and fancies of the executive. Yes, it is not at the will of the executive. However, they can be only removed on the grounds mentioned under the constitution and in the manner mentioned under the constitution. Yes, what else? Yes. There is huh? Yes, the parliament or the state legislature cannot curtail the jurisdiction, and the jurisdiction of the Supreme Court or the High Court cannot be curtailed by the legislature. They can only be increased but not reduced by the legislature. All this ensures that the judiciary is able to exercise independence. If the jurisdiction could be curtailed, supposedly they, under the constitution, they have been made protector of fundamental rights. If supposedly that jurisdiction can be taken away, then the Supreme Court will have to operate in a way so as to not estrange the legislature, estrange the executive in a parliamentary form, such that they do not take such adversarial action. So you find that the parliament cannot curtail. It is the sole arbitrator of federal disputes. That power can be not taken away from the Supreme Court. Fine. So that is the idea, that their jurisdiction cannot be reduced. They can be increased but not reduced by the parliament or the state legislature. Fine. Fine. So these are some of the ways in which independence of judiciary is ensured. So we'll write it in a more sequential manner. Write it down. Point number 1, appointment of judges. Appointment of judges. Under it, write down the legislature. The legislature does not affect the appointment of the judges. Does not affect the appointment of the judges. Write down, for a person to be appointed, for a person to be appointed, comma, he or she must have experience as a lawyer, or be well versed in law, or be well versed in law. And there are certain conditions mentioned under the constitution according to which only when those conditions are fulfilled you can be appointed as a judge. Yes, his should be well versed in law or should be well versed, 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 well versed in law. He should be a well known jurist. अगर lawyer नहीं भी है, if he is a well known jurist, there is an option of his appointment as a lawyer to the Supreme Court. Judge to the Supreme Court. Yes, next point, इसी में लिखो यही वाला में, the same point, his political loyalty or opinion should not be a criteria for his appointment. Yes. Second is fixed tenure. Under fixed tenure, write down once appointed, judges hold the office until they attain the age of retirement. Full stop. इसी में लिखो next point. They can be removed only on the grounds and only in the manner as mentioned under the constitution. The third point, the salaries, allowances and pensions. Are charged on Consolidated Fund of India. They are charged on Consolidated Fund of India. Semicolon, not subject to vote by the Parliament. Not subject to vote by the Parliament. Next point, fixed service condition. Write down their salaries, pensions, allowances, cannot be changed to their disadvantage. After their appointment. Cannot be changed to their disadvantage after their appointment, except during financial emergency. except during financial emergency. Yes. Then you have the conduct of the judges. The conduct of the judges cannot be discussed. Yes, conduct of judges cannot be discussed in the parliament or the state legislature. Cannot be discussed in the parliament or the state legislature except when a motion for their removal is being considered. नहीं लिखा है हमने. Except when a motion for their removal is being considered. Yes. And last point. The jurisdiction and powers of judiciary cannot be curtailed by the parliament. But can only be extended. Yes. So you find that all these factors ensures independence of judiciary. Achha, one factor which we have missed in this discussion is power of the Supreme Court and High Court to punish for the contempt of court. Yes, that is also a very important power given to the judiciary to ensure its authority and dignity. Yes, power to punish for the contempt of the court. Yes, और इंडिया में क्या है बोथ है ना, ये है सिविल कंटेम्प्ट ऑफ कोर्ट के लिए भी पनिश कर सकते हैं या क्रिमिनल कंटेम्प्ट ऑफ कोर्ट के लिए भी पनिश कर सकते हैं. तो at times it is criticized as a colonial vestige, just as laws of sedition. Laws of sedition क्या है, आपने न्यूज़पेपर में आता रहता है. Laws of sedition क्या है, when somebody has criticized the government, at times the government imposes a sedition law and gets that person arrested. However, the use of sedition law is expected to be very, very limited in a democracy. It should be used only when the person through his speech or action is inciting violence. तभी sedition का law use करना चाहिए. So sedition law is known to be a counter to freedom of speech and expression. तो sedition law कौन यूज करता था, colonial power यूज करते थे to control freedom of speech and expression, to prevent spread of nationalism in the country, expression of nationalism in the country. But sadly that law has continued even presently. Governments of the day tend to use sedition law when an individual is found to criticize them. Yes, to check criticism of the government, which was not meant for the purpose, and it is being used. Similarly, there is this idea of contempt of court, whereby the court can punish an individual if the individual willfully does not follow the judgment of the court or willfully interferes in the functioning of the court such that ability of the court to give justice gets affected. Yes. However, you find that this is also a colonial vestige. In UK, today there is no concept of criminal contempt of court, but only there exists civilian contempt of court, and that is also very rarely used. But in case of India, we continue to have provision for both criminal as well as civilian contempt of court. अभी बस लेकिन हम यही लिखेंगे, this power of the court to punish someone for the contempt of the court ensures that the court's authority, court's dignity remains intact. There is no dilution in its authority and dignity. Nobody can not follow the judgment, willfully not follow the judgment, or willfully interfere in the administration of justice by the court. ठीक है, लिखो, कर सकते हैं. अगर there is a will in the government, they can and they should change. तो वही दिक्कत है ना. It has become an instrument to control criticism of the government by the common people. तो यही होता है कि in fact there was है ना, कई बार Supreme Court comes out with judgments where it cancels certain laws, है ना. जैसे IT का भी एक law था, उसका एक section was used by the government to control criticism of the government, है ना. तो that was Supreme Court ने ऐसा judgment दिया कि this law is unconstitutional and ultra vires. हाँ, कुछ तो देखो, इंडियन कॉन्स्टिट्यूशन में एक क्रिटिसिज्म है इंडियन कॉन्स्टिट्यूशन का. इनफैक्ट कॉन्स्टिट्यूएंट असेंबली के एक मेंबर ने कहा था, इंडियन कॉन्स्टिट्यूशन मेक्स elaborate declaration of freedoms, of fundamental rights, but from one hand it is giving those freedom and from the other hand it is taking those freedom away because of so many restrictions imposed. तो वही है कि though we are a liberal democracy, freedom of speech and expression, you can criticize the government, rule of law, constitution is supreme, and we popular sovereignty, people are sovereign, not the government. Government is supposed to serve the people. Yes, all such things are true, but at the same time you find concentration of power in the hands of the executive. Yes, तो वही है कि freedom of speech and expression the constitution guarantees, but then there are such laws, yes, which continue to curtail such freedoms which are guaranteed. देखो, सुप्रीम कोर्ट भी आर्बिटरली नहीं कर सकती. उसके पास अगर केस आएगा, है ना, इट कैनॉट. अगर सुप्रीम कोर्ट, if supposedly Supreme Court thinks that I am the organ which is to ensure justice, I am the organ which is supposed to ensure a democracy, rule of law, everything should function in a particular way, उसका indirect impact क्या होगा? Concentration of power in the Supreme Court. Supreme Court itself will become like a dictator. Yes, so there has to be a balance which is to be maintained. No organ should take upon itself thus to be the only organ to ensure a democracy, to ensure a rule of law. When opportunity presents, Supreme Court does give those judgments. अभी भी उन्होंने electoral bonds, they have cancelled electoral bonds, they have questioned their constitutional validity. Yes, so you find that whenever the opportunity presents, they will come out with such judgments. But सुप्रीम कोर्ट, एक आइडिया है जो हमने यहाँ पे डिस्कस नहीं किया है, जुडिशियल एक्टिविज्म, है ना. तो ये सब क्या है? जुडिशियल एक्टिविज्म, जहाँ पे वो अपने डोमेन से निकल के लेजिस्लेचर के डोमेन में घुस के कुछ काम कर रहा है या एग्जीक्यूटिव के डोमेन में घुस के कुछ काम कर रहा है. ठीक है, तो मिनिमम जुडिशियल एक्टिविज्म इज अप्रिशिएबल. जुडिशियल एक्टिविज्म की जरूरत क्यों पड़ती है? जुडिशियल एक्टिविज्म को हम लोग अच्छा मानते हैं. हम अच्छा क्यों मानते हैं? देखो क्या है, पहले हमने पढ़ा 3 ऑर्गन है, तीनों ऑर्गन के बीच में डिस्ट्रीब्यूशन ऑफ फंक्शंस है एंड इधर कोई भी ऑर्गन एक दूसरे के साथ इंटरफेयर नहीं करना चाहिए, दैट इज सेपरेशन ऑफ पावर. बट यू फाइंड दैट सुप्रीम कोर्ट एट टाइम्स गेट्स इनटू द डोमेन ऑफ लेजिस्लेचर एंड कम्स आउट विथ सर्टेन लॉ, gets into the domain of the executive and announces certain executive action to be taken by the government. जब ये limited होता है, this is known as judicial activism. When it occurs in a limit, we appreciate it. Why? Because it pushes the other organs into action. What has forced the judiciary to pursue judicial activism? When the government has not made a law on it. For example, Election Commission of India. Yes, we will study. We have not studied election, or we have studied? we have studied, है ना. तो Election Commission of India में we had studied the appointment of election commissioners. When it came to election commissioners appointment, Supreme Court in March last year had come out with a judicial pronouncement that the election commissioners are to be appointed in such a manner. Why? Because the legislature over 75 years has failed to enact a legislation for the said purpose, and this pushed the government to come out with its own law, है ना. तो इसलिए जुडिशियल एक्टिविज्म अप्रिशिएबल है. लेकिन अगर जुडिशियल एक्टिविज्म ज्यादा होने लग जाए तो उसको हम बोलते हैं जुडिशियल ओवररीच, which is not good. Yes, because then it seems as if judiciary is concentrating power, and let us please remember, it is non-representative. It is the least representative organ in a democracy, है ना. तो इसीलिए गवर्नमेंट अपना क्रिटिसिज्म रोकने के लिए इसको एनफोर्स करता है. वो नहीं चाहता, क्योंकि क्या है, पब्लिक ओपिनियन, आपने अपना ओपिनियन. मीडिया को क्या बोला गया है? मीडिया को बोला गया है फोर्थ पिलर ऑफ डेमोक्रेसी. बिकॉज द फैक्ट ऑफ द मैटर इज, मीडिया क्यों है फोर्थ पिलर ऑफ डेमोक्रेसी? बिकॉज वो लोगों के पास सही इंफॉर्मेशन पहुंचाए. यस, प्लस पीपल हैव अ टेंडेंसी, देखो, रोल ऑफ मीडिया इज टू गिव इंडिपेंडेंट इंफॉर्मेशन सो दैट ऑल ऑफ अस कैन मेक आवर माइंड अकॉर्डिंग टू हाउ एंड व्हाई वी थिंक इन अ पर्टिकुलर मैनर. बट व्हाट हैपेंस इज, men and women, if we have not given any opinion in the class and I ask you a question, yes or no, there might be certain division. कुछ लोग बोलेंगे yes, कुछ लोग बोलेंगे no. लेकिन जब आपको पता चल जाएगा कि अधिकतर लोगों का ये ओपिनियन है, all of us will mold our thinking into one way. Yes, so that tends to happen. So वही है कि अगर गवर्नमेंट का क्रिटिसिज्म बहुत खुल के होने लग जाएगा, people will become little critical. They will become aware, oh, the government is doing this wrong, and they are more vocal to criticizing. They don't want such criticism. So the governments which have dictatorial tendencies, इसीलिए colonial government ने sedition law बहुत use करते थे. Democratic governments were not expected to use, but वही है ना कि there will be exceptions. So governments which have greater dictatorial tendencies tend to use it more, but we find that they have been used, अब चाहे ज्यादा या कम, but they have been used throughout India's history of independence. We find their usage. Yes, fine. Fine. Yes, write down the last point, लिख लेते. 7th point लिख दो. Judiciary can punish any person for its contempt, CONTEMPT, for its contempt. Yes. Thus its actions and decisions cannot be criticized or opposed. It helps judiciary to maintain its authority and dignity. Yes, fine. So these are the ways in which judiciary exercise independence. This is the manner in which judiciary exercises its independence. Next is appointment of judges. We'll discuss appointment of judges. Give the subhead as appointment of judges. We have discussed independence of judiciary. Now we are discussing appointment of judges या appointment to judiciary. Yes. So this is the constitutional provision. Yes, the constitution under Article 124, Clause 2 says that the judges of the Supreme Court are to be appointed by the President. They are to be appointed by the President after consultation with such judges of the Supreme Court and of the High Court in case of states as the President may deem necessary for the purpose. Yes. However, in case of appointment of a judge other than the Chief Justice, the CGI is always to be consulted. So what is the Constitution saying? Constitution under Article 124, Clause 2 reads that the judges are to be appointed by the President. Yes, and he may consult. Yes, he may consult the judges of the Supreme Court or High Court. Yes, as he may deem necessary. The key word kya hai? May. He may. It is not making it obligatory on the President to consult the judges of the Supreme Court and High Court before appointment of the judges to the said courts. Yes, he may consult if he deems it to be necessary. Yes, however, the Constitution has mandated that he must consult the CGI, Chief Justice of India, in case of appointment to other in case of appointment of other judges. Yes. So by the virtue of this article, the power to appoint has been given to the President. But we know the President in India is a constitutional head. He is a figurative head. He does not enjoy a lot of discretionary power. His powers of discretion arise only in extraordinary circumstance. So agar he is to be appointed, if the judges are to be appointed by the President, that would actually mean that the real power is exercised by the Council of Ministers, by the COM. Yes. So that is the problem. The Constitution, by not making it obligatory for the President to necessarily consult the judges of the Supreme Court and High Court in case of appointment of the judges to the respective courts, made the COM powerful with respect to appointment of the judges. If the COM is powerful, then there is this problem of fear and favor. Yes, the judges might be influenced by those who are responsible for their appointment. They might have obligation to be shown to those who have appointed them as judges of Supreme Court and High Court. Yes, so this was the issue that has been a matter of discussion when it comes to appointment of judges in Supreme Court and High Court. In fact, because it was the COM which got to exercise a lot of power in terms of appointment, a number of cases came in front of the judiciary starting from 1982 till then there was another case in 1993 and then in 1998. Yes, there were thrice cases which came in front of the judiciary which sought to elaborate as to what is the nature of consultation that should happen between the President and the judges. Yes, what is the nature of consultation? Is the President bound to consult them? What is the nature of the opinion that is given by the CGI? Is it binding? क्योंकि यहाँ पे भी क्या है? CGI should always be consulted. लेकिन अब जो इन्होंने opinion दिया है CGI ने, will it be binding or will it be advisory? क्या nature of opinion होगा, है ना? All that came up to be discussed in the various cases starting from 1982 till 1998 between in front of the Supreme Court. And Supreme Court, through a series of judgment, has clarified what is the nature of opinion that is given by the CGI, and should it be necessary, should it be compulsory for the president to consult the other judges of the Supreme Court and High Court? Yes. In fact, it is through these judgments that we find that what came to exist was the collegium system. So collegium system is an innovation of the judiciary that comes to exist in context of clarification on Article 124 Clause 2. ठीक है, तो अभी क्या हुआ? In fact, in the case, in the 1982 case, which is also known as the first judge's case. Yes, in the first judge's case, the Supreme Court said that yes, the consultation with CJI is essential, but the opinion given by the CJI will not necessarily be binding, on the precedent. Yes, will not necessarily be binding. He should consult, but his opinion is not binding on the precedent. However, in the next second judge's case, the Supreme Court changed its view. Yes, in the second judge's case, Supreme Court changed its view. It said that the opinion given by the CJI will be binding on the precedent. Also, the CJI's sole opinion is not sufficient. He should consult other judges of the Supreme Court before giving an opinion to the precedent. Yes. And finally, in the third judge's case, Supreme Court clarified, yes, the opinion is binding, plus there has to be plurality of opinion. So basically, the sole opinion of the CJI will not be considered as binding on the precedent. Rather, the CJI should consult given a number of High Court and Supreme Court judges before forming this opinion. Yes. So the Supreme Court said, in case of appointment of a judge to the Supreme Court, in case the judge is to be appointed to the Supreme Court, the CJI must consult 4 senior most judges of Supreme Court. And supposedly these 4 senior most judges would not include the future CJI, then this future CJI should also be consulted. Yes, because this judge who is to be appointed will serve under the future CJI. So yes, so their opinion totally should be given by the CJI to the precedent. Yes, and even supposedly of the four senior most judges, even if 2 of them out of these 5 individuals, CJI and 4 senior most judges, even if 2 judges do not agree vis-a-vis appointment of a certain individual, then that person's name should not be sent to the precedent. And all the consultation that takes place between them should be written and documented. And it should take place in a written manner. Fine. Also, in in the third judge's case, the Supreme Court clarified that in case appointment to the judge to the High Court is concerned, in such a case, the CJI should consult the Chief Justice of the said High Court. Yes, of the High Court in which the person is to be appointed, plus 2 senior most judges of Supreme Court. Yes, so this consultation has to take place, and it is the cumulative view and not the sole opinion of the CJI that would be binding on the precedent. Fine. So that is how the appointment is to take place. Yes, and through this mechanism, the collegium system has come into being. Fine. Let's write down. Write down. You have given the heading appointment to the judiciary. Yes, write down under article 124 clause 2. The judges of Supreme Court, the judges of Supreme Court are appointed by the President after consultation with such judges of the Supreme Court and High Court, such judges of the Supreme Court and High Court as the President may deem necessary, as the President may deem necessary. As the President may deem necessary. Full stop. However, in case of appointment of a judge other than the CGI, the CGI must always be consulted. The CGI must always be consulted. Yes. Write down, give a small subhead in practice. तो कॉन्स्टिट्यूशनल प्रोविजन तो ये है in practice. Yes. In practice क्या है? You find that as far as appointment of CGI has come into being, a convention has developed that the senior most judge of the Supreme Court will be appointed as the CGI. ठीक है, ये convention develop हो गया है कि जो senior most judge है, in fact the outgoing CGI tells the name of the person who is to be appointed as the next CGI, and it is just based on seniority, है ना, ऐसा convention develop हो गया. However, you find that this is only a convention. So you find that this convention has been broken twice. Yes, once when Keshwananda Bharati judgment came, the government of India, of course, was unhappy with the judgment. Yes, why? Because it restricted the power of the parliament to amend the constitution. पावर ऑफ द पार्लियामेंट का पार्लियामेंटरी फॉर्म में एक्चुअली मतलब क्या है, एग्जीक्यूटिव का पावर कर्टेल हो गया टू अमेंड द कॉन्स्टिट्यूशन. So in that case, those judges who had gave an opinion in favor of the basic structure doctrine, they were superseded. Yes, and a junior judge was made the CGI. और एक बार दूसरे बार भी एक बहुत फेमस केस है, एडीएम जबलपुर केस. ठीक है, वो एक बहुत फेमस केस है ड्यूरिंग द पीरियड ऑफ इमरजेंसी विथ रेस्पेक्ट टू हेबियस कॉर्पस का जो रिट है ना, उस कंटेक्स्ट में वो जजमेंट था. एंड इन दैट कंटेक्स्ट ऑल्सो द गवर्नमेंट वॉज अनहैप्पी, सो दे डिसाइडेड टू सुपरसीड द सीनियर मोस्ट जज and appoint his junior as the CGI. Fine, so this convention has been broken twice. However, when it came to the appointment of other judges, it led to, this article led to concentration of the power in the hands of the COM, as we have discussed, and later on these cases came in front of the Supreme Court, whereby it has given its opinion, leading to creation of collegium system. Let's write down. In practice, लिखो points में. Point number 1, a convention has developed whereby in case of appointment of the CGI, the senior most judge of the Supreme Court the senior most judge of the Supreme Court is appointed. Is appointed. Yes. Write down. Only twice has this convention been broken. Yes. Next point, write down. With respect to appointment of other judges, the President is constitutionally mandated. The President is constitutionally mandated to consult the CGI. To consult the CGI. Full stop. However, given the lack of clarity as to what consultation meant, led to concentration of power, with the COM, with respect to appointment of judges, Yes. Next point, thus in a number of cases between 1982 to 1998, comma, clarity as to what is meant by consultation with CGI came up. Yes. So because it led to concentration of power with the COM, therefore there was need to elaborate what it means consultation with the CGI. Yes. अब इन points लिखो. Subpoint A, 1982 case या first judges case. 1982 case or the first judges case. इसमें लिखो Supreme Court opined that consultation with CGI was not binding on the President. Second subpoint, 1993 case or the second judges case. Yes. Write down. Supreme Court reversed reversed its previous ruling, reversed its previous ruling, and now opined, that consultation meant concurrence. Consultation meant concurrence. Meant concurrence. CONCURRENC. Concurrence. meant concurrence. Concurrence का मतलब क्या है? It will be binding. Whatever the CGI opines will be binding on the precedent. Concurrence you can underline and in single inverted commas. That is the advice of the CGI. The advice of the CGI will be binding. Will be binding. Full stop. Third judge's case. Third subpoint. Third judge's case. 1998. The third judge's case, 1998. लिखो सुप्रीम कोर्ट क्लैरिफाइड या फर्दर क्लैरिफाइड. सुप्रीम कोर्ट फर्दर क्लैरिफाइड the sole opinion of the CGI. The sole opinion of the CGI would not be sufficient. Would not be sufficient. Would not be sufficient. Yes, CGI should consult. CGI should consult with plurality of judges. With plurality of judges. And all such consultation should be in writing. Should be in writing. Yes. Write down. The third judge's case created the collegium system. Collegium system of appointment. Created the collegium system of appointment. Yes. इसी में लिखो एक छोटा सबहेड दो. In case of appointment of Supreme Court judges. In case of appointment of Supreme Court judges. Collegium system को underline you can underline the collegium system of Supreme Court judges. Of Supreme Court judges. Yes. तो Supreme Court के judges में किनको consult करना पड़ेगा? Yes. President will appoint based on this consultation that takes place between CGI and 4 senior most judges of the Supreme Court. लिखो appointment by president. Appointment by president. On a recommendation of CGI and 4 senior most judges of Supreme Court. And 4 senior most judges of Supreme Court. Yes. And in case of appointment of judges of high court, in case of appointment of judges of high court, yes, who will be the appointment of the judges of high court and supreme court, कौन appoint करता है? प्रेसिडेंट. इन बोथ केसेस है ना, हाई कोर्ट और सुप्रीम कोर्ट दोनों के जजेस को प्रेसिडेंट ही अपॉइंट करता है. तो लिखो अपॉइंटमेंट बाय द प्रेसिडेंट. अपॉइंटमेंट बाय द प्रेसिडेंट on the recommendation of CGI plus Chief Justice of the High Court concerned plus the Chief Justice of the High Court concerned plus two senior most judges of the Supreme Court. In fact, the governor also is consulted. State में appointment जब होगा तो consultation with governor also takes place, है ना. Senior most judges of the Supreme Court plus governor of the state, ठीक है. एक और लिखो. We'll have to check. I think so the oath must be administered by the governor, but I'll have to check कि कौन administer करता है oath for the judges of the high court. ठीक है. तो judges of the high court आपने लिख लिया. इसी में chief justice of the high court लिखो. appointment of chief justice of the high court, chief justice of supreme court on the basis of seniority, वो तो convention है. generally seniority on the basis of age, है ना. that is the convention कि अभी कि experience चाहे थोड़ा कम हो, but seniority on the basis of age is generally the criteria. ठीक है. in case of appointment of chief justice of high court, चीफ जस्टिस ऑफ हाई कोर्ट में किन किन को कंसल्ट करेंगे? ठीक है. अपॉइंटमेंट बाय द प्रेसिडेंट, कंसल्टेशन है सीजीआई प्लस है ना, कंसल्टेशन विथ सीजीआई प्लस टू सीनियर मोस्ट जजेस ऑफ सुप्रीम कोर्ट प्लस द गवर्नर Yes, appointment is of course by the president, but consultation with CGI, governor and two senior most judges of the Supreme Court के साथ consultation है. हाँ, of Supreme Court सारे judges Supreme Court के ही consult हो रहे हैं. Yes, so this is the collegium system which has come into existence because of the third judge's case. Yes, and this is the consultative process. The consultation takes place in writing also. Fine. Now collegium system has got created. Is yes, oath of office high court judge is administered by governor of the state. Yes, Ankita ma'am has clarified. Yes, it is administered by the governor of the state. Fine. Now the collegium system has got created, but is the collegium system the perfect system? Yes, there are certain challenges with the collegium system. We are not very happy with the collegium system. Why? What is the problem with the collegium system? Yes, collegium system के साथ सबसे बड़ा problem है lack of transparency. It is a very opaque system. Yes, behind closed doors such consultations takes place. Yes, and there is lack of clarity. What is the criteria? There is no clarification on what is the criteria that they are looking for in a judge. On what grounds is the consultation taking place? What are the grounds for a person to qualify to become judge of the Supreme Court? So the process is very very opaque. Yes, एक तो कोलिजियम सिस्टम के साथ ये दिक्कत है, और क्या दिक्कत है? This collegium system has failed to fill the vacancies in time. And a Supreme Court and High Court often have a large vacancies of judges. And India is a country with such a large population. Anyways, there are so many cases. है ना? There are crores of cases which are pending before the Supreme Court. And it is also believed, जैसे मैंने कहा, justice should not just be done, it should be seen to be done. Similarly, justice in time is essential for it to be justice. Yes, so if you have such large pending number of cases, such large number of under trials, we cannot believe that the system to be just. Yes, and it is essential that the judges are able to perform their duties, but the judges are overburdened. The process of the collegium system involves senior most judges. They have so much workload that they are not able to proactively fill the existing vacancies, which would help ensure easy timely disposal of cases also. Fine, so they have failed to fulfill the vacancies. और क्या problem है? हाँ, मेरिट बेसिस क्या है? यही है कि कंडीशन क्या है, कंडीशन नहीं पता. मेरिट पे उनको सजेस्ट कर रहे हैं या उनके पर्सनल चॉइसेस दे आर मेकिंग. हाँ, आरटीआई के थ्रू पर्दा करने की कोशिश करी थी, बट सुप्रीम कोर्ट हैज रिजेक्टेड दोज आरटीआईज. यस, सो आई थिंक सो इन अर्ली 2000 है ना, 2 or 3 RTIs were filed before the Supreme Court to get an hint, to get an idea with respect to what is the criteria, what is the process that they follow, how is the consultation taking place, what grounds are they considering. Yes, but the Supreme Court का जो registry है ना, they had rejected the RTI saying that Supreme Court does not come within the scope of the RTI. Yes, so RTI के through भी नहीं पता कर पाए. Yes, yes, accountability concerns. क्या हो रहा है? Last problem क्या है कि this idea that they are not within the scope of RTI. They said, I forget the exact word now, है ना, पब्लिक अथॉरिटी नहीं है वो, या पब्लिक सर्विस में नहीं, ऐसे करके कुछ वर्ड है. उन्होंने कहा हम वी डू नॉट फॉल अंडर दैट क्राइटेरिया. बट इन फैक्ट how can it be? So there were questions raised once again vis-a-vis accountability of the Supreme Court itself, accountability of judiciary. They are performing a vital public service. How can they not be accountable? Yes, when we are talking about independence of judiciary, we are not saying that judiciary should be unaccountable. Yes, we are not saying that the judiciary can act arbitrarily or judiciary can concentrate power in self. So it is a case, collegium system has led to concentration of power. Yes, concentration of power in judiciary. And to correct it, there was this idea of NJAC, National Judicial Appointment Commission. However, the Supreme Court in the 4th judge's case in 2015 rejected NJAC to be unconstitutional, saying that it would affect the independence of judiciary. But we find that we generally are critical of the Supreme Court for rejection of the entire idea of NJAC. Maybe they could have suggested some modification if needed, but what has happened under the collegium system, that there is concentration of power in the judiciary itself. Yes, but anyways, presently what is operational is the collegium system of appointment, and that has come to being through the 3 judges cases. Fine. Anyways, अभी लिखो collegium system का criticism लिख लो. Criticism of the collegium system. Criticism of the collegium system. Criticism of the collegium system. Yes, लिखो point number 1. It is shrouded in secrecy. It is shrouded, S-H-R-O-U-D-E-D, shrouded in secrecy. Shrouded, S-H-R-O-U-D-E-D, shrouded in secrecy, lack of transparency. Lack of transparency. Yes. Opaque process of appointment. Same ही point में लिख रहे हैं सारे points. Opaque process of appointment. No clarification of the criteria of appointment. Of the criteria for appointment. Second point. Second point. It has failed to fill judicial vacancies in time. Yeah, vacancies of judges in time. It has failed to fill the vacancies of judges in time. And third, concentrates power in the hands of judiciary. Concentrates power in the hands of judiciary. Yes. लिखो, next point लिखो. Therefore, through the 99th Constitutional Amendment Act, through the 99th Constitutional Amendment Act, the Parliament created NJAC. Parliament created NJAC, National Judicial Appointment Commission. National Judicial Appointment Commission. However, the Supreme Court, through the fourth judge's case, declared NJAC, Supreme Court, through the fourth judge's case, 2015, declared NJAC to be unconstitutional. Yes. Unconstitutional. And last point, presently the collegium system is operational for appointment of judges. Yes. Fine. Fine. So this is with respect to the appointment of judges of Supreme Court and High Court. Fine. Let's take a 5 minutes break and then we'll discuss removal of judges. Okay, we'll discuss removal of judges. We are taking a 5 minutes break, or else let's take a 10 minutes break and we'll discuss removal of judges. Yes, starting once again. Next, we are going to discuss removal of judges. How are the judges of the Supreme Court or High Court removed? पहले लिखो, give the heading removal of judges. क्या है प्रोसेस ऑफ रिमूवल? हाँ, नहीं, प्रेसिडेंट का रिमूवल जैसे होता है, कैसे एग्जैक्टली बताओ कैसे? Violation of constitution is used only for impeachment of the president, not for the judges. ठीक है, जजेस के लिए दो क्राइटेरिया मेंशन्ड है, proved misbehavior or incapacity. The Supreme Court, the Constitution does not clarify what it means misbehavior, what it means proved incapacity. But they have mentioned these words only on these two grounds, that the judges of the Supreme Court and High Court on proved misbehavior and incapacity. ठीक है, proved misbehavior and incapacity, इन दो grounds पे the judges of the Supreme Court and High Court can be removed. Yes, and for their removal there needs to be special, such resolution need to be passed through special majority. What is that special majority? 2/3 of the members present and voting plus the total strength of the house. Yes, so it is only on these two, है ना, these are the two ways. हम डिटेल में नहीं जान रहे हैं एग्जैक्ट प्रोसीजर के, but these are the two ways, है ना, two processes through which the legislature will say that yes, this judge is to be removed. The parliament will say that the judge is to be removed, and within the same session, this motion, the motion which has been passed by the parliament has to be presented to the president, and then the judges are removed. Yes. Has there been any judge of Supreme Court and High Court that has been removed in India? The process is so stringent, the majority requirement is so stringent that we do not find a single judge to have been removed by the process mentioned under the Constitution. Only once a case against one of the judges came forward on the ground of corruption, है ना? In fact, yes, the discussion took place, so proved misbehavior के context में there was a discussion, the motion was put to vote. However, one of the parties, the Congress party at that point of time, chose not to vote, है ना? So once the members did not vote, as a consequence the absolute majority criteria, है ना, was not achieved, and consequently the judge could not be removed. Fine, let's write down. Removal of the judges. Write down the judges of Supreme Court and High Court. The judges of Supreme Court and High Court can be removed by the president, can be removed by the president on the grounds of proven misbehavior or incapacity. Proven misbehavior or incapacity, underline. Write down next point. The motion for their removal, the motion for their removal has to be passed by a special majority, has to be passed by a special majority. That is 2/3 of the members 2/3 of the members, 2/3 of the members present and voting, and majority of the total strength of the house, and majority of the total strength of the house. Strength of the house. Majority of the total strength of the house. Yes. Total strength of the house. Full stop. Write down the process of removal. The process of removal has been made stringent. Has been made stringent so as to has been made stringent. Stringent matlab difficult. Yes, stringent. Stringent or difficult, so as to further augment, या further ensure, so as to further ensure independence of judiciary. Yes, to further ensure independence of judiciary. अगर बहुत आसान प्रोसेस होता देन दे कुड हैव बीन इजीली, अगर सिंपल मेजॉरिटी के थ्रू इस तरह के motions would have to be considered, then it would have been relatively easier to augment the independence of judiciary further. Next point लिखो, no judge of Supreme Court or High Court has been removed this far, has been removed this far, except for one case of removal that came up but the required majority could not be achieved. Fine. Fine. So this is the process of removal of judges. इसमें what is unique about the process of removal of judges? Appointment में कौन से branch का role था? Executive का role था as such, because he is to be appointed by the president and president will act on the advice of the COM, है ना? ऐसा ही होता है, COM के advice पे act करेगा. But under the process of removal, the role has been given to the legislature, which was not the case when in case of appointment. This is another way to ensure independence of judiciary. Yes, let's write down this. write down note करके लिखो. In case of appointment of the judges, the executive plays a prominent role. However, in case of their removal, it is the legislature, which plays an important role. Yes. Yes. Fine. So this is with respect to removal of judges. Next is structure of judiciary in India. What is the structure of judiciary in India? Integrated hierarchical system of court. Yes. Unlike अभी क्या है, फेडरल कंट्रीज में क्या होता है ना, इंडिया इज अ फेडरेशन. Yes, that means there is distribution of power between center and state, and the source of distribution of that power is the constitution. Yes, we are not a unitary form of government like UK, but we are a federal form of government like the US. So whenever there is a federal form of government, there is generally a parallel system of courts that operate at center and state level. So there will be a federal court which will enforce the central laws, and then there will be courts at the state level which will enforce the state laws. But in case of India, what do we have? Yes, we have a single system of court, or we have what is known as single integrated judicial system. We have a single integrated judicial system. That means a single system of court enforces both central as well as state laws. Yes, so we have a single integrated. It is quite unlike for a federation not to have a parallel or separate courts for the state. A parallel system of courts is a norm for the federation. Generally in a federation you have a parallel system of courts, but India has single integrated judicial system. Also, the Indian judiciary is hierarchically arranged. It is hierarchically arranged. That means in a pyramidal structure, the judiciary of India has been arranged. On top is the Supreme Court, below it is the High Court, and below it is district courts and other subordinate courts. Yes. So we have a single integrated judicial system which is hierarchically arranged, and the judiciary in India enforces both center and state laws. And this system of judiciary we have adopted from the Government of India Act 1935. Yes, fine. So this is with respect to the structure of judiciary in India. Yes, let's just mention it. Structure of judiciary in India. Right? Write down. Unlike other federations, India does not have parallel system of courts at center and state level. Full stop. Rather India has an integrated judicial system which is hierarchically arranged and organically linked. Write down. Hierarchically arranged mein you can just draw this pyramidal structure. Supreme Court, High Court and District Court. Yes. Write down the single system of courts in India. The single system of courts in India enforce both center and state laws. Enforce both center and state laws. Full stop. It has been adopted from it has been adopted from Government of India Act 1935. Government of India Act 1935. Yes. Fine. So this is with respect to the structure of judiciary, and the last topic is jurisdiction of Supreme Court. What are the various types of jurisdiction of the Supreme Court? We have something known as the original jurisdiction. Original jurisdiction क्या है? Yes, it acts as a federal court. So the original jurisdiction of the Supreme Court is also its exclusive jurisdiction. It is the only court which will resolve the federal disputes between union and state and amongst the states. Yes. Then there is appellate jurisdiction. Appellate jurisdiction, yes, it hears appeals from the lower courts. Then advisory jurisdiction, whereby it advises the president whenever the president refers to the Supreme Court to opine on matters of public importance and law. Yes, whenever there would be involvement with respect to interpretation of the Constitution, the president can refer the matter to the Supreme Court for its advice. Then it also enjoys writ jurisdiction. This writ jurisdiction that the Supreme Court has is original, but it is not exclusive. है ना, ये जो फेडरल कोर्ट का jurisdiction है, that is original plus exclusive, but writ jurisdiction is original but it is not exclusive. Original का मतलब क्या है? People can approach the Supreme Court directly in case of violation of fundamental rights. So under Article 32, an individual whose fundamental right has been violated can directly go and approach the Supreme Court and not necessarily as a matter of appeal. However, it is not exclusive because there is a choice to the people. They can also approach the High Court rather than going to the Supreme Court. But you find that though the High Court also has writ jurisdiction, but the writ jurisdiction of the High Court is wider. एक तो in case fundamental right has been violated of an individual, and if the individual chooses to approach the High Court is not necessarily bound to issue writs. It can provide remedy through other measures also. जरूरी नहीं है कि writ ही issue करे. Yes. And secondly, it can issue writs vis-a-vis some other issues as well. है ना? तो you find that there is wider jurisdiction of the High Court when it comes to writ jurisdiction. Writ jurisdiction is an original jurisdiction but not exclusive jurisdiction of the Supreme Court. Then there is something known as special power. Special power of the Supreme Court is vis-a-vis special leave petition. The Supreme Court can issue can allow है ना special leave petition. Yes, it can grant special leave to an appeal from any judgment or matter passed by any court in the territory of India. That means कि general क्या है, general hierarchy क्या है? You go to the district court, the district court gives you a judgment, you are unhappy with that judgment, you reach the high court, high court will give a judgment. If you are still unhappy, you go to the Supreme Court. Yes, but in case of special leave petition, it might so happen that you just had gone to the district court and the district court gave a judgment with which you were not happy, and now you have chosen directly to appeal to the Supreme Court. So it is not necessary that you follow the procedure of hierarchy. Yes, you do not follow that order that has been given under the Constitution, but rather directly go and approach the Supreme Court to get redressal of your issue. Yes, so you find that special leave petition, Supreme Court has a special power to grant special leave to appeal to Supreme Court from any judgment and at any level. Fine. However, you find that when it comes to special leave petition, there is concentration of power in the Supreme Court. It gives Supreme Court a lot of power. In fact, special leave petition can since क्योंकि इसमें इतना ज़्यादा power है, so we also refer it to being a source of plenary power. Plenary power मतलब है ना, extraordinary power है Supreme Court के पास. It acts as a reservoir of power for Supreme Court, and therefore Supreme Court has opined that it should be used, it should be used in a restricted manner. The special leave petition should not be misused. Since it is plenary in nature, it becomes a source of large power. Fine. Do you all understand? We know it already. We'll just briefly mention it. Yes. Give the heading as jurisdiction of Supreme Court of India. Jurisdiction of Supreme Court of India. First point would be Federal Court. Federal Court. Write down. It settles disputes. It settles disputes between union and states. And amongst the states. Yes. It is also called original jurisdiction of the Supreme Court. Because only Supreme Court has the power, because it is also called as original jurisdiction of the Supreme Court, because only Supreme Court has the power to deal with such cases. Yes. Original jurisdiction you can underline, write down in this capacity. In this capacity, the Supreme Court not only settles the disputes, but also interprets the Constitution, with respect to the respective powers, of the state and the center. Yes. Fine. Next, let's write down writ jurisdiction. writ jurisdiction. Write down, it can issue writs, it can issue writs to protect fundamental rights. Write down, writ jurisdiction is original jurisdiction of the Supreme Court. Is original jurisdiction of the Supreme Court. That is an aggrieved citizen can directly go to the Supreme Court and not necessarily by the way of appeal. Yes. Directly and not necessarily by the way of appeal. In bracket mention article 32. Article 32. Yes, full stop. Next इसी में लिखो however next point, however it is not an exclusive jurisdiction. It is not an exclusive jurisdiction, as writs can also be issued to protect fundamental rights लिखो, and as writs to protect fundamental rights can also be issued by the High Court. By the High Court. By the High Court. Yes. Therefore, a person has the option to approach either High Court or Supreme Court. Yes. Next point लिखो. Difference between writ jurisdiction of Supreme Court, या तो लिखो writ jurisdiction of Supreme Court versus writ jurisdiction of High Court. Difference between writ jurisdiction of Supreme Court versus High Court. Yes. क्या है डिफरेंस बताओ. writ jurisdiction of Supreme Court. Yes. Yes, it is mandatory for the Supreme Court to issue writs in case of violation of fundamental rights. लिखो. It is mandatory for Supreme Court to issue writs. It is mandatory for Supreme Court to issue writs. And a difference between the writ jurisdiction we are mentioning. So, it is mandatory for the Supreme Court to issue writs in case of violation of fundamental rights. Yes, और writ jurisdiction of High Court में क्या है? It is not mandatory. लिखो इसमें in case of violation of fundamental rights, in case of violation of fundamental rights, High Court may or may not issue writs. Yes. एक तो ये डिफरेंस है. दूसरा डिफरेंस क्या है? सुप्रीम कोर्ट issues writs only in case of violation of fundamental rights. ठीक है, but high court can issue writs for other purposes as well. ठीक है, तो इसी वजह से हाई कोर्ट का रिट jurisdiction is considered to be wider. Yes, write down second difference. Supreme Court issues writs. Supreme Court issues writs only in case of violation of fundamental rights. Only in case of violation of fundamental rights. Full stop. Yes, however, High Court can issue writs not only for enforcement of fundamental rights, not only for enforcement of fundamental rights, but for other purposes as well. But for other purposes as well. Thus, High Court's writ jurisdiction is wider. Thus, High Court's writ jurisdiction is wider. हाँ हाँ, नैरो है क्योंकि वो सिर्फ फंडामेंटल राइट को एनफोर्स करने के लिए ही रिट इशू कर सकता है. प्लस इट इज मैंडेटेड, हमने वो पहला पॉइंट पढ़ा था कि इट इज मैंडेटेड टू इशू सच रिट्स. बट हाई कोर्ट के पास इट कैन इशू रिट्स फॉर एनफोर्समेंट ऑफ फंडामेंटल राइट्स एज वेल एज फॉर अदर मैटर्स. ठीक है, एंड एज शी वाज मेंशनिंग कि आर्टिकल में भी डिफरेंस बता दे, तो आर्टिकल में क्या डिफरेंस है, इधर आर्टिकल 32 है और हाई कोर्ट के कंटेक्स्ट में आर्टिकल 226. ठीक है, बट इट इज नॉट नेसेसरी, आप मेंशन करो तो अभी अपने मन से कर लो, बट अदरवाइज फ्रॉम आर पर्सपेक्टिव है ना, प्री फाउंडेशन में हम नहीं भी मेंशन करेंगे तो भी चलेगा. ठीक है, आर्टिकल 32 वर्सेस आर्टिकल 226. ठीक है, तो सुप्रीम कोर्ट का रिट जुरिस्डिक्शन का सोर्स है आर्टिकल 32 एंड रिट जुरिस्डिक्शन फॉर हाई कोर्ट इज सोर्स फ्रॉम आर्टिकल 226. फाइन. Fine, so this is with respect to writ jurisdiction. Next is appellate jurisdiction. Yes. Appellate jurisdiction. वहाँ पे लिखो, it is the highest court of appeal. Highest court of appeal in civil, criminal and constitutional matters. In civil, criminal and constitutional matters. Yes, and इसमें एक और पॉइंट हम मेंशन करते हैं कि सुप्रीम कोर्ट हैज रिप्लेस्ड ब्रिटिश प्रिवी काउंसिल as the highest court of appeal. है ना, before India's independence the highest court of appeal was British Privy Council. ठीक है, तो ब्रिटिश सिस्टम में there is something known as British Privy Council. ठीक है, in British system British Privy Council is the highest court of appeal, and since we were colonized by the Britishers, so for us also the highest court of appeal used to be the British Privy Council. But once India gained independence, once India created this body called as the Supreme Court, we have replaced the Supreme Court, replaced the British Privy Council and emerged as the highest court of appeal in India. Yes, let's write it down. Supreme Court replaced highest court of appeal, replaced British Privy Council, replaced British Privy Council as the highest court of appeal, as the highest court of appeal. Yes. Next is advisory jurisdiction. Yes. Write down. Write down the Supreme Court is expected to offer advice, legal advice, is expected to offer a legal advice to the President in two categories of matter. In two categories of matter. दो तरह के matters में the Supreme Court is expected to offer advice to the President. One is on matters of public importance and law. देखो सब पॉइंट में लिखो, सब पॉइंट ए on matters of public importance or law. Yes. अब इस तरह के मैटर पे सुप्रीम कोर्ट हैज अ चॉइस टू ऑफर एन एडवाइस or not offer an advice. The president can approach a Supreme Court that give us advice on matter of public importance and law which has arisen or is about to arise. But Supreme Court can give an advice or can refuse to give an advice. But in another case, in case of some pre-constitutional treaties, agreements that India agreed into, and before India's independence, if certain agreements, treaties of which we were part of, with respect to that, if the President seeks advice from the Supreme Court, then the Supreme Court is bound to give that advice. But as the name suggests, it is just the advice that it is giving. So it is not binding on the President per se to always follow the advice tendered by the Supreme Court. Yes. तो लिखो, इसमें आपने लिखा है फर्स्ट इशू क्या है, ऑन मैटर्स ऑफ पब्लिक इंपॉर्टेंस एंड लॉ. पुट अ हाइफन. The Supreme Court has a choice. The Supreme Court has a choice to offer advice, or refuse, to offer advice, है ना. Full stop. Second category of matter, write down, on disputes arising from pre-constitutional treaty, comma, agreements, etc. Put a hyphen. In such case, Supreme Court is bound to give advice. When asked by the President. Yes. Next point लिखो. However, in both cases, the advice is not binding on the President. Yes. And last is special powers. special powers. Write down under it, Supreme Court is authorized. Supreme Court is authorized to grant special leave. To grant special leave. Grant special leave to appeal from any judgment. Grant special leave to appeal from any judgment passed by any court in India. Passed by any court in India. Yes. So a person can take up the matter to the Supreme Court, not necessarily by the way of appeal. So it is a special leave that Supreme Court can grant from appeal against any judgment by any court in India. Yes, and at its discretion, Supreme Court at its discretion gives that special leave when asked, when sought. Write down, in such case, the aggrieved person can take the matter directly to the Supreme Court. Directly to the Supreme Court. Yes, write down, this power is very wide. This power is very wide. Very wide. Thus Supreme Court itself has held then that since it is a plenary power, हमने ये ना इसमें यूज किया था ये वर्ड when we had discussed Election Commission of India, we had talked about plenary power. Plenary power मतलब very wide, large scope of power है ना, it acts as a reservoir of power. ठीक है, तो that is plenary power. क्या लिखा आपने? Since Supreme Court has since it is plenary power, comma, the Supreme Court has held that it should be used sparingly. Yes, fine. So this is with respect to sparingly. मतलब ज़्यादा नहीं यूज करना है. Yes, restricted use करना है इसका. Though it is discretionary power, since it is plenary in nature, it should be used sparingly. Yes. So this is with respect to the jurisdiction of the Supreme Court. With this, in fact, we conclude our topic on judiciary as well. Yes. The next topic that we are expected to start is federalism. Yes. But I think so we'll not start the topic of federalism today. We are left with 3 topics: federalism, amendment and local government. ठीक है, तो हमारे ये जो 3 टॉपिक्स है उसमें हम डिटेल में, रिलेटिव डिटेल में जो पढ़ेंगे would be federalism. Amendment is a very small topic, and then local urban government is there. So that also we discuss only from PRI perspective, Panchayati Raj institution perspective. So we'll not start with the topic of federalism today. We'll leave it at judiciary in the next class, day after tomorrow, and after that. Yes, so 2 more classes and we'll be able to complete our syllabus comfortably. Fine, so we'll discuss federalism in the next class. Fine, that is it for today then. Thank you.